I go.
I will investigation officer. Coupled to the doc, that is more than enough. To come to the conclusion that it's
Please come to page 45, paragraph 12. Page 45. Page 45, paragraph 12. No, more than that, it is for him to sustain that. Right, so he is the local.
Here, in this case, the tribunal what has PW1, not and PW3 and PW2. PW2,
the appreciation you leave it. We are not on the question. It should not be re-appreciated. We are with you on that count. Please come to paragraph 12, page 45.
In view of that,
You had only two witnesses there also. That is PW1 and an investigating officer. The police investigating officer. Except that there is no other evidence.
in the departmental inquiry, in the what the officer is, some evidence. The evidence of PW1.
Correct.
This is not on the theory of pre-conference of program.
Absolutely.
PW1 complainant has completely supported the case. He has stated that his evidence is not attacked by the tribunal. He has stated.
What was he working as?
He was the commercial tax officer. To issue the PIN number and registration of lot, he has demanded the money.
How much is the
1,500 he was demanded. And the money is demanded in respect of demand and acceptance.
Please show it. Please show it what is recorded by the tribunal. Page?
Page 301, 30. Internal page 16 of the tribunal.
Yes. Correct.
Here, my lord. Among them, PW1, the complainant has reported that he is the resident of Belgaum village and the husband of Color and considers and also is a skill contractor. Number and tax registration. DWD complete down, and he was at complete called him to his mobile and asked him to meet him in a hotel. He met DJ1 Kumarappa in a hotel. Give a report in this his case. Therefore, he should meet him.
That's all right. So please come to page 31, last 4 lines. And the DGO 1 and 2 are what? Color did not say.
Yes, Lord. He did not handle the money. What he has asked is, he asked the complainant to keep Lord in the blue color box. Blue color file. He did not handle.
So we understand that that may have happened. We are not saying that. But today, post government after what is it? Paul's case. Paul, GM Tank, Paul Antony, GM Tank, and the line of decisions.
Latest and the end garage will not be support. The evidence will not end garage.
Give it. Whether those authorities have been considered in this?
Yes,
please give.
End garage will not.
Paragraph?
No, paragraph is not. Respect of acquittal not. Paragraph 5 not starts. grievance.
So grievance is all right. What does the court say? Statement of law.
Para 7 Malad is we find that interference in the order of punishment, the tribunal, para 7. Punishment the tribunal appointed by the High Court suffer from judicial review is confined to the decision making process. Conferred on the constitutional court tribunal is an appellate authority. But only Malad the
See, Mr.
please.
That law is settled from London Plebiscite 1929, All England report. This decision-making process, the spectrum from one end to the other end, that has flown from nearly for more than 100 years. That's not an issue. So the question is about this. Certain exceptions were made that these people should not suffer in the hands of both criminal cases as also the departmental inquiry. That is not. This is a well settled principle of law. This statement cannot be, no exception can be taken for this. All right. Now the question, we asked you a very specific question. In the event that GM Paul Anthony, GM Tank, etc., whether they have been considered or whether they have been distinguished, there is no point in, see, every day in Supreme Court or in this court or any court, hundreds of cases get disposed of. Every judgment is not an authority. It's a statement of law. If it is considered previous one and if it changes any position, only then it becomes it. We are asking you simply on facts. Judgments won't help you. Don't. What is that? What is it? You must state the position of law. Then. Huh?
The department inquiry, the proof is what is required is there is some evidence about it.
Correct.
And that's not in the criminal case.
Correct.
To prove this is also arising out of Karnataka local. Just do one paragraph.
Please show.
Referring to all earlier judgment.
Please show.
I just 16.
Para 16.
Yes.
Yes.
Different from applying.
No problem. That is correct.
The prosecution for any offense principle in the criminal law, the burden lies on the accused I apply is to inquire into an allegation of misconduct.
See, Mr. On principles, we have no doubt. You must produce authorities if we do not know that position of law. Isn't it? So the question is, we are telling you upfront. The question is, all these matters have to be considered on the facts of the case.
Yes,
Correct.
in the present matter, you see the word the trial case not is
You forget about that also because that's a criminal case.
criminal case. Then
So what have you done? Yes, let him just sustain the order. What have you done in the departmental? You have brought the PW1. You have brought the police officer. Only 2 persons.
And not existing P3.
What is that?
Which is also proved. Which has been PW2, the shadow witness. He has also not admitted regarding the drive of Panchana.
There are only 2 witnesses. Where is the PW? Who is PW?
PW2 is the shadow witness. Before the inquiry. 3 witnesses were at least.
3 witnesses.
Yes. And
Please show PW3. In the department, where is the department inquiry order?
running this
4. Next, see the examined. Where is it?
impact page 125, paragraph 28. 28.
Yes.
Page 125.
Yes.
Para 128.
Right. That's right.
report of the in the case of this corroborates the IO's evidence about PW2 stating that when the DCO1 was met, he asked the complainant PW1 to pay the bribe amount, and when offered, he asking the complainant to keep the money in a blue file on the table. Hence, PW3's evidence coupled with the direct evidence of that the complainant kept the bribe amount in a blue file at an instant of DCO1, and on his asking, and the same was recovered and why was found on the table of DCO2 is not significant to discard the evidence which shows that the bribe amount was demanded by DCO1. By asking the same to be kept in a file, most to the point, Exhibit P3 draft measure further shows that the IO had entrusted a voice recorder to the complainant before draft proceedings for recording his conversation with DCO1, and the same was recorded, and the conversation showed that DCO1 asked for bribe and asked the complainant to keep the money in the file. The IO has recorded the list of the conversations recorded on voice recorder at page 5, paragraph 4 of the draft measure. PW1 has deposed in his evidence about the IO playing a voice recorder and making all the conversations at time of the P3 draft measure. The fact that CD contained conversation is not true is not a conversation
And notice. Yes, next.
Yeah, got aspects clear.
Correct. Whether it's an aggrieved party or not. So you are the employer.
Yes, I'm the recipient. The issue is pending.
Is under consideration. That's all. Anyway, we have made it. We have issued. Right.
case, export as well. The Lokayukta has the
Locus.
and one more judgment of December court, which clearly directly had that Lokayukta has the institutional interest that has been confirmed. The judgment of the site.
Girish, zero compliance, the Girish I have got, the Girish is implementing.
Yes.
As confirmed by the
What is the allegation?
allegation is that Lord on the date, petitioner was working as moratorium in the bank. Okay, get back after some time with a customer and moratorium created after
So you are a bank employee.
Like,
You are removed from service. You are challenging the removal.
yes,
Yeah, in this writ petition.
not direct, it's for the appellate.
The appellate authority.
Or the respondent number 1, that is what the
Bank appellate authority is an officer of the bank or senior officer, whatever, and a board consisting of 2 or 3 persons. The matter must come before the honorable single judge.
that is the part for the CH-1 as per what it says.
CGIT, when you say so, that's all right. That is all right.
Then what else?
So it's a reference to CGIT. It must correctly state, otherwise we are a little concerned. How can it? Right.
CGIT order.
There is a CGIT order.
Page number 77. And the third portion commences from page.
What is the allegation against you?
Allegation.
When did you join service?
In the 1992,
And when you are removed?
2009. No, 1992 I was appointed as an award staff in the bank. Then when I was promoted to the post of clerk after what I completed.
My lord says there is a finding with regard to 2 years.
That corrected products. 85 has appointed as award staff. 92 after the position of patent expert.
1 minute.
Then in 2009,
Your 12 to the period of consideration is 12 to 2005 to 14/7/2008. Is that right?
that is what regarding for delegation of another sales. There are two charges. One is that for specifically on 8/9/2008.
So what are the charges?
Two charges. The first one is that on 8/9/2008, I had obtained for a deal from the bank. In fact, after 1 hour, with a customer seeking order to help you. At that time, order is a both the order of the bank as well as the manager are examined.
Which is the other allegation?
Other allegation regarding the
That is first. So how many days another is that?
total orders I have calculated is 132 days.
You must show that this finding is wrong, Mr.
That's what I am trying to say. If I interest order to pending
Oh, see, the fact of the matter remains, page 89. CG80 headed by an honorable judge, a former judge of this court, has recorded a finding of fact. 638 days. Page 80. See, don't argue just like that. You must be very systematic. When we ask a question, Mr. Young lawyer, please follow what we are saying. We must give an order. Ultimately, there is no point in simply keeping on arguing something. We must be convinced of this. We are putting a very pertinent question. Yes, please come to page 89.
Yes.
This finding of fact is recorded by a former judge of this court.
Yes.
How do you get over this finding?
That's what I was trying to say. Earlier, the order was passed on 1/4 at that time. One increment was limited. There, once for order absence.
The time, the check period or the time period as you call for unauthorized absence is 2005 to 14 to 2008.
Yes.
Even not even under the KCSR, 120 days. If you are continuously absent for 120 days, you are out. It's all right, but the point is within this span,
He has stated that
2 years you are absent.
he has stated that the applications were given at 22 documents. Because we are not producing. Main allegation is that incident on 8/9/2008 that has my criticism was controlled by the bank earlier. I should have tried to make out for this by passing an order of punishment by holding money.
Where is that? Please show.
Because that was very good for page number 40.
40.
Yes, sir.
That's right.
Part of section A1. This is the letter of paragraph number 4, order of page number 40.
Correct.
Charge number 2. That is letter dismissal of the from duty without grant. That was the aforesaid misconduct on his part on the of by the effect. And it was punishment.
That's it. According to we are concerned with 12 to 2005.
Yes.
Please show us from 12 to
After 12 to 2005, one. And the periods of also mentioned in the table below. This order is part order. The table below may kindly see. This order is order 132 days. It itself says that number of days is 132 days. Therefore, it would not have been 638 days is my observation.
I argued all these facts. You can't come back like this.
This is one aspect.
No, sir, it is not like that. Let any court pass any order, I'll come to superior need. You can't do like that. Then take it back, go file a review before that court. These are all factual matrices.
One aspect.
It is not one aspect. Appeal can be allowed if there is an error in law. On facts, so long that the facts, if you say that no, sir, there is a mistake in fact, you must file a review, but law is settled on that. And if you want, take it back and file a review. Yes, after arguing the matter for some time, learned advocate for the petitioner seeks leave to withdraw this petition with liberty to file a review petition before CGIT. He has filed a memo to this effect. Memo will be kept in record. Leave granted, petition dismissed and withdrawn with the he has paid for. Thank you all interlocked. It goes on.
Number 6, Sri Sharanabhatwa, that's
All interlocked applications come up. Keep training, stand disposed.
Sri Anil Kade.
That's problem. This is yes, Sharon, sir. So what do you, why did you go to KSAT? You went to KSAT, right? You have challenged KSAT's order. KSAT's order, Karnataka State Administrative Tribunal's order. Why did you go to Administrative Tribunal? Order of? Like the interested submatter to under section rule 14. 14A, right? As excise inspector. Correct. How does that come in? There is some irregularity in issuance of CL1 license, correct? So that could be. See, your employer has thought it appropriate. Let us see where that interest. One second. The name?
My name is 2%.
Check. Correct. This order, you cannot perhaps say that it is. It's a very well considered order. We are telling you for this reason that please come to para 1, 2, and 3. That is Aidane Appaditaru. Page 105. These are all unnumbered. Come to fifth, the third para. ಐದನೇ ಆಪಾದಿತರು ಆಯ್ತಾ, ಅದು ನೋಡಿ ಬಿಟ್ಬಿಡಿ ಅಲ್ಲಿ, ಅದೊಂದು 2-3 ಲೈನ್ ಏನ್ ಅದು ನಾಟ್ ರಿಕ್ವೈರ್ಡ್. ಇವರ ವಿರುದ್ಧ ಅವರ ಲಾಸ್ಟ್ 2 ಲೈನ್ ಆಪಾದನೆಗಳು ರುಜುವಾತ ಬಗ್ಗೆ ಏನು ಹೇಳದ ಕಾರಣ, ಮೇಲಿನ ಆಪಾದನೆಗೆ ಪೂರಕ ಸಾಕ್ಷ್ಯದ ಕಾರಣ ಅವರನ್ನು ವಿಚಾರಣೆಯಿಂದ ಕೈ ಬಿಡಲಾಗಿದೆ. Government has applied its mind and thought it, examined the papers, said that sir, about this person there is no material. Therefore, no inquiry is required. That's exactly what we are saying. Is it is not simply a clerical order without examining the papers. They have looked into the file. They have examined, given reason why this person's no inquiry is required against this person, and let him off. In your case, please see this. Come, kindly see that. Then we'll listen to your argument. These are fundamental. We want you to please examine and tell us the answer. Please come to the last paragraph. ನೀವು ಓದಿರ್ತೀರ ಬೇಕಾದಷ್ಟೇ, ನಾವು ಮಾರ್ಕ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀವಿ. ಮೇಲ್ನೋಟಕ್ಕೆ ಮತ್ತೊಂದು ಪ್ರಕರಣದಲ್ಲಿ ಯಾವುದೇ ಮೂಲಭೂತ ಸೌಕರ್ಯ ಇಲ್ಲದಿದ್ದರೂ CL4 ಅನ್ನೋದು ಪಡೆಯಲು ಬೇಕಾಗಿರುವ ಅನುಕೂಲತೆಗಳು ಕ್ಲಬ್ ನಲ್ಲಿ ಇವೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿ ಗದಗ ಜಿಲ್ಲೆಯ ರಾಯಲ್ ಸೋಷಿಯಲ್ ಕ್ಲಬ್ಗೆ ಹೊಸದಾಗಿ CL4 ಅನ್ನೋದು ಮಂಜೂರು ಮಾಡಲು ಶಿಫಾರಸು ಮಾಡಿದ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸೋಯನ್ಸೂರವರು ಕರ್ತವ್ಯ ಲೋಪ ಎಸಗಿದ್ದಾರೆ. ಇದನ್ನ ನಾವು ಇದು ಇಲ್ಲ ಅಂತ ನಾವು ಹೇಗೆ ಬರ್ಕೊಡ್ಬೇಕು ಹೇಳಿ?
Present petitioner here not in charge, not this put it on side. But he the intern not write a letter to the circle inspector of the commissioner of excise. The deputy commissioner of excise was forwarded the same to the after the minutes when the application was pending before the minutes the applicants for the license was withdrawn. My minutes against me, that minutes only allegation is that minutes I have into the minutes blueprint. That is the minutes only allegation against me. This minutes it was arranged in charge arrangement.
We will come back to that. We will not move further like that. We'll unless this point is clarified, whatever argument will be there on. Position is, he is your employer. He has examined the file. There is an allegation. He said, so and so person not money. I have not found anything. No inquiry is required. Where this person, meaning to say your client is concerned, you have done 2 things. This time also you have said that there is ಮೂಲಭೂತ ಸೌಕರ್ಯ ಇದೆ ಅಂತ. ಇನ್ನೊಂದು ಕೇಸ್ನಲ್ಲಿ CL4 ಲೈಸೆನ್ಸ್ಗೆ ಬೇಕಾಗಿರುವ ಅನುಕೂಲತೆಗಳು ಕ್ಲಬ್ ನಲ್ಲಿ ಇವೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿ ಗದಗ ಜಿಲ್ಲೆಯ ರಾಯಲ್ ಸೋಷಿಯಲ್ ನಲ್ಲಿ ಹೊಸದಾಗಿ CL4 ಅನ್ನೋದು ಮಂಜೂರು ಮಾಡಿ ಶಿಫಾರಸು ಮಾಡಿದ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸೋಯನ್ಸೋ ಅವರು ಕರ್ತವ್ಯ ಲೋಪ ಎಸಗಿದ್ದಾರೆ. ಅದು ಅವ್ರ ಆಫೀಸ್ ನಲ್ಲಿ ನಿಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ನಿಮ್ಮ ಬಾಸ್ ಬರ್ಕೊಟ್ಟಿರೋದು. ಅವ್ರು ತಪ್ಪಾಗಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಾವು ರಿಟರ್ನ್ ಹೆಂಗ್ ಬರ್ಕೊಡ್ಬೇಕು? That's all you want, no? Today, why you have come to court? You want this to be, this 3 sentences to be taken out or held to be bad in law. If what your commissioner sits in his office, sees a file, writes a report, can we in a writ petition record a finding saying that no, that commissioner is wrong?
Since it was a blueprint, I have simply not signed
you may have an excellent defense, but that is a time of inquiry.
I have blueprint.
That's what we are saying. That's what we are saying. That you may have an excellent defense, but this is not the stage.
I will not just have to be better. In the present case, take wants to.
Sorry.
Under the act of
Sorry.
under the act,
We will, for a moment, we'll say that there is nothing. There is not your lokayukta, no uparokayukta. Can't your employer, if you find it's simple. Corporate. What do you want? You want to take this defense in your departmental inquiry, or you want a closure by us? Your choice. Whatever you like, absolutely your choice. We have nothing to say about it. We'll just pass it over and before the other, because this list will get over in no time. Before the list over. Thank you. Also.
Number 7, Sri PM Devashetty.
Yes. Right. What is the violation? Correct, sir. What is the violation? Dispose of so and so to extend UGC pay scale. Sir, who is the person? Sir, sir, GA sir is it all? Is it complied? Agidya. Notice. Notice.
8, Sri AS Patil.
What is the direction?
My direction was to the state government
To do what?
to consider the recommendation made by the Karnataka. Just request for 1 week's time.
Complied is it? Does it?
This is not it.
He may have instructions. Learned GA submits that as per his instructions, the order has been complied with. He seeks a week's time to complete the instructions and to file compliance memo. One date for the
Number 9, Sri AS Patil.
Pursuant to the
done. All right. Mr. Patil submits that compliance has been done. Memo filed. Complaint closed.
what challenge the endorsement because they have
Of course, with liberty to challenge the endorsement. Related such yes. All interlocutory applications, if any, stand dismissed of.
Number 10, Sri MP Vivek.
There is a conflict of 10 years. Main occasion is given of the occasions are 100. These are the bad prevention in other cases. You should have noticed. In 1 lakh, 532
insurance. 1 lakh?
1 lakh, 532
This has been ordered.
Notice has been ordered.
Shri Mehta, learned advocate for the appellant, submits that to this court in similar cases as issued this in WA 1053 of 2023 submission based on records. Based on
That's the main state.
1 minute. Issue notice. Post along with this. Post with the letter B 1053 of 2023. Up to 16 is it? Except 11. 11.
Number 11, Sri Dinesh Kulkarni. By 3. 17, Sri Praveen T. Tarika.
he was that the other from the service. What that
What was he working as?
he was working as doctor.
Later
Later on,
how many days was he absent?
plus
3 months.
plus after that, what I took this initial appointment, contact with some appointment was it was plus he was regularized. In the year 2006, it was not this. When he was working at plus I took this. One day,
Yes.
after that, back to the
110/2009 to 17/7/2012. Is that right? So it is nearly 3 years, Mr. What is the penalty order? Contract. Sir, was he on? Where is that order? That cannot happen. The words you are very, very, very distinct uh, in every order. Was he on your regular road?
No, he is not. He is not. Exactly, he is not.
Was he on probationary period?
He was on probation. Since meantime, after the inquiry from Richard, meantime, he approached the criminal. During that time, he died. The last week, on record.
We may not have much difficulty so far as his right to prosecute, but the point is, prima facie, I think you see, is 2009 to 2012. It's too long a period.
I'm not sure. I'm not saying.
It's like an Arab scammer. ಕೇಳಿದಿರ ತಾವು ಕತೆ ಅರಬ್ ಸ್ಕ್ಯಾಮಲ್ ಕೇಳಿಲ್ವಾ ಮರುಭೂಮಿಯಲ್ಲಿ ಬಂದು ಹೇಳಿದೆ ಮೂಗಿಗೆ ಸ್ವಲ್ಪ ತೊಂದರೆ ಆಗಿದೆ ಸ್ವಲ್ಪ ಇದ್ರಲ್ಲಿ ಬರ್ತೀನಿ ಅಂತ once it comes it will say it will keep on coming and it will completely approve the Arab and you see the Arab will be out, his camel will be inside. Again, I will only ask this hanging now. We can't say that for this purpose we are issuing. Either you get an order or you don't get an order. That's it. It's purely on law. Any sympathetic view has to be taken, Mr. Advocate. It cannot be regularized. If it cannot be regularized, nothing can be done in this. Please tell us a solution in law. If you show us a solution in law, we can try to exercise our indulgence.
Professional without passing departmental exam. Regularized ನೀವು ತೋರಿಸಿ ಜನ ಸಿಬ್ಬಂದಿ outcome.
Sorry, bad case. Backward. So and so. One Dr. Rajashekar. First, contract basis as a doctor, as a physician. Really? Manvi. In PHC Manvi. According to the learned advocate for the petitioner, services were regularized. And he was in the probationary period at the material point in time. An inquiry was conducted on the allegation that he had remained absent on the allegation that on following allegations, bullet point 1, that he was an alcoholic and consuming liquor during the working hours, and he had remained unauthorizedly absent between 1/10/2009 to 17/7/2012. Correct? Correct. The inquiry officer found him guilty of charges. Both charges? The disciplinary inquiry, the disciplinary authority discharges from service. Feeling aggrieved, petitioner, Rajashekar challenged the order passed by the disciplinary authority before case act. Charges reverse now. Bullet point. No, reverse now. First unauthorized. Feeling aggrieved, Rajashekar challenged disciplinary authorities order before the case act. He passed away whilst the matter was pending before. Whilst the matter was pending consideration, he passed away on 8/5/2000 by the impugned order. The case head has dismissed the application. Hence, petition. Sri so and so for the petitioner submitted that ಏನಿದ್ದು ಅಷ್ಟಿಲ್ಲ ಅಂತಾನ the period of unauthorized absence mentioned in the charge sheet is factually incorrect. Rajashekar was suffering from illness. Indisposed, therefore he was unable to attend the office. So that Rajashekara's services were given the Rajashekara, yeah, services were regularized, not have been discharged from service. Para. G, comma, is order. There is no material placed by Rajashekara to show that he was absent. As per the records, Rajashekara was absent between 1/10/2009 to 17/7/2012. Opportunity has been given to him departmental inquiry. You held an inquiry, no? Published. He was unauthorizedly absent. The period of unauthorized absence is correctly alleged. Well, with reply to the contention that Krishna's Rajashekara's services were regularized. Uh, regularized. That Rajashekara could not have been discharged. He submitted that regularization under probationary period, and the same was not declared. As he had not passed the departmental examinations. Therefore, the the discharge order is just an appropriate. Carefully considered driving convictions and various records. Considered facts of the case are petitioner was working as a temporary employee. Referee was working as a contract employee. Services the department had considered for regularization and placed him, yes, and placed him on probation. First of but whilst he was when he was in the probationary period, department inquiry has taken place. The specific case of the government is that the petitioner had remained absent nearly 3 years. Semicolon. He had not passed the departmental examination. He had been discharged from service. So, these facts are not disputed by learned advocate for the para. It is also not in dispute that the Rajashekara passed away while the matter was pending before the case act. So, the unauthorized absence is nearly 3 years. Inquiry, more, it is not petitioner's case that it is not the case of it is not petitioner's case. Petitioner's case that Rajashekara had to defend this case. The inquiry officer has recorded the finding that both charges Noted here. Now go ahead. Move. It is settled that in a service matter, the court, in a service matter, the courts cannot substitute their opinion. If some material was available before the inquiry officer, so in judicial review, what can be seen is whether principles of natural justice were complied with, whether there was material to appreciate for the inquiry officer to arrive at conclusion. The penalty imposed is disproportionate. So, in the case on hand, Rajashekharaya was in probationary period. The inquiry officer has found, has accorded on appreciation of evidence that case act has concurred with the view taken by the inquiry officer. So, having reconsidered the matter on merit and no ground to interfere, we are at one with the view taken by the case act and where petition bills dismiss no part. Interlocutory applications come if any stand disposed of.
18, very good.
Yes. Contempt. What is the violation? Dispensation. All right. I1 dispense for 3 months. What is IA2? Same IA1 and 2 dispense. Ordered production of certain document dispense for 3 months.
19,
Both IA is disposed of. Yes, Ravi.
Lord, 19 is direction portion.
What is the direction?
Direction is to today, 130 of Karnataka, say 19.
This. Like this.
Number 20, Sri Jagdish Patil.
Yes.
My lords, Mr. Naganan is on another court hold. May I request for a pass, my lord?
So, we have very few matters. No?
My lords, in a short pass, 5 minutes. My lords, because there's a direction for us to comply by today, so this case may kindly be considered.
All right. Before these matters conclude, if you come spare. All right. Thank you. Also,
Please.
For B group matter, 021, the Avinash Naka, the Venkatesham Karvi.
yes. No. Petitioner. He has to argue. No? Fair enough, but we have to hear both sides and pass it on. Isn't it? Yeah. Appears for the petitioner, so and so for the respondent, all and such the Sanjay 3.
Number 22, Sri Sanjay Stragari.
of India, postal report. Lords, the respondent sought for get the old pension. Their appointment ultimately itself for that is election itself, they have
They were, when were they appointed?
after
1/1/2004.
yes, sir.
What is the date of that new scheme? New scheme coming into force.
Scheme it was on
They were appointed in the new scheme.
yes, sir, 26.
So they were not, therefore they are not entitled.
And not ended.
What does the
Yeah, the CAT says the lot, again order dated where they were appointed. Order include, which is at page 20 melons.
zero?
Yes, 6431 order came to pass. Page 21 melons.
All right.
Their notification was 2002 melons. In fact, those they undergo the training and everything, but their appointment.
This is 1/1/2004, fresh appointment.
Yes, sir. This is 26. In fact,
We got it. We got it. Rule.
Number 23.
You have a stay order already.
Number 23. Santosh P. Mane, CGP.
Sorry? So it's a 6 time. Whichever the date you want, please take. Government.
7.
Forest range officer.
A investigation, so much investigation was conducted by the Departmental program. With respect to 1670, there is some data scheme relation to planting of roads side saplings.
Who gave the complaint?
It's a so moto by the local.
Based on paper notification.
And the local conducted the spot inspection.
Happened. Finally, what happened?
On that basis, not the local on the submitted report. This is the preliminary inquiry. The government has entered the inquiry and thereafter article charges were issued by the honorable court.
What happened finally?
That order is challenged by this person for the KT.
What is the reason recorded for quashing that?
Two reasons. The local cannot conduct inquiry under the proceedings once the employee is retired. The government has no power to enter the inquiry to the local 214.
Is the root position?
I just do not judgment says you can. I have a judgment. Number two, the main reason allowing the application is the incident took place in the year 1670. The article charges were issued
4 years beyond.
214 And we conducted the inquiry after beyond 4 years. That's the one.
And what is to be done?
So, my submission is with respect to that delay is concerned. This is some disputed issues there that has to be brought one by the inquiry officer while conducting.
What is the dispute?
The reason is the reason.
517.
17. The inquiry in the year around 14/12/2017 itself.
14/12/17.
2017 and 15/12/2017 the spot inspection were conducted. Found that it was not properly.
When did you frame the charge and serve the other person?
Charges were framed on 7/8/2020. 20.
So please calculate from 31/5/2017.
4 years ago.
I will know.
So that is the reason for that. That issue has to be authenticated by the inquiry officer.
31/5/17, 18, 19, 20. 3 years ago.
That's the reason for that. That issue has
Notice.
to be.
25, BB Badal 3.
So 6 time. Follow the date. Yes, government.
43. 026, government freedom.
Previous matter, Mr. Vijay Naik for R1 and Adil Kale, they are here. So rule. Mr. Notice rule. Previous 24 year rule out. 26. Government. So it's a 6 time. Respondent 6 time. Follow the date.
The issue is the short order. See the blood order. Granting certain return benefits by counting blood under the regular rate of the The issue is pending for the arbitration. Not this judgment passed on the following the order possible. But we already given an endorsement in the main matter where not file. The main issue whether they are entitled for the benefits or not is the matter.
What is the list about?
The list he approached the KT.
Who is he?
He is an employee of Karnataka.
So what happened to him? Why did he go to KSAT?
KT is sitting in the voting past service before the regularization. Till the date of the regular.
So he has been regularized.
Regularized.
He wants that past service.
Past service. Till his initial appointment.
Correct, we got it. So what is the order?
The order is date order. Is saying that
Matter is pending in Supreme Court.
no, that is not. In matter, the judgment on which application is relied, we have given already endorsement. Holding that the issue whether he is entitled for that period, his matter was pending for the Supreme Court. Till the matter is decided, we cannot put that we have given endorsement.
Still he is in service.
No, he is already
Retired. So what should happen now when the Supreme Court will decide when they will get?
Cannot do it. It's a problem because they give a direction to consider it. The members which is there at election.
Anyway, she wants time more. That's fit for the respondent 6 time.
Already states that.
Call on such and such date. Yes, the password is there. No, what are the password?
Number 6.
Which matter?
Number 6.
Varula. Sorry?
He is not taking this one.
But on merits you argued, what can be done? There is nothing. we would have given you some liberty, that's a different matter. But your client is not available, not available. There's nothing in this because government, there's the same thing, no? Government has applied its mind, it has let off one person, about the other person, he has started. Certain position. All right. Doesn't advocate seek some time for on such a date. Next week or week after. Which is the other one? Somebody said some senior advocate is coming.
Number 20, Sri Jagdish Patil.
Not I appear for
Yes.
High Court administration for your lordship. Not in this case.
One minute, 1 minute. Come through this. Admit. What is the order now?
Not the order, not your lordship may consider saying it not. There's a direction to the Registrar General. Calculate.
Admit interim order as prayed for.
Okay.
I even allowed interim order as prayed.
Sorry, not held up in the earlier round.
Doesn't matter. Thank you.